9 a.m. Bond continued with its conditions. Thank you. Court calls case of the People versus David. Is it Machasik? Machasik?
Good afternoon, Your Honor. Allie Zenda on behalf of the people.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Machasik. And sir, can you unmute and state your name for the record, please?
He took it off, stupid.
Okay, look. I don't know who you are, Life 3, but you're about to be kicked out of the courtroom. Mr. Machasik, can you figure that out? If you can't figure it out, there should be a clerk right near you somewhere. You can ask them for help to unmute.
From the very beginning, this courtroom hearing is already close to becoming chaotic, and Judge Simpson notices it right away. What should have been a normal virtual hearing quickly takes a wrong turn when someone makes insulting comments over an open microphone, forgetting that this is a courtroom and not a social media comment section. You can hear the judge trying to stay in control before things get worse. His tone suggests he knows the hearing could become a problem at any moment. Virtual court hearings can be unpredictable because people sometimes forget they are still in a legal proceeding. The microphones are live, the cameras are on, and one careless remark can affect how a judge views a person's attitude, maturity, and credibility. Judge Simpson stops the behavior immediately because disrespect in a courtroom can quickly create bigger problems. After the interruption, everyone's attention shifts to Nathalie Mason, and it becomes clear that this hearing is not going to be a typical one. The tension is already rising before her case has even officially begun. And honestly, when a judge sounds frustrated less than a minute into a hearing, it is often a sign that things could escalate very quickly.
I apologize, Judge Simpson.
Who are you?
Nathalie Mason.
Got her. Okay, I don't want to ever hear that in my courtroom about anybody.
I apologize.
I don't know if that's going to be good enough, but I'll get you when you get to your case. Mute yourself.
Yes, Your Honor. This is John David.
Court calls the case of the People versus Nathalie Mason. That's the one, right?
Good afternoon, Your Honor. Allie Zenda on behalf of the people.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Miss Mason. Miss Mason, please unmute and state your name for the record. Miss Mason, please unmute and state your name for the record.
Had a whole lot to say before.
Miss Mason, we're ready for court now. Would you please unmute and state your name for the record?
I already got in trouble because I thought I was muted and I wasn't. And this guy, he was calling this guy name. He was sitting there looking crazy. I was like, he's looking off.
Miss Mason, we got
but I didn't know harm.
Miss Mason, will you state your name? State your name for the record, please.
Nathalie Mason.
Thank you, Judge. Today is the date and time set for pretrial in this matter. I've spoken to Miss Mason and to the prosecutor's office.
How'd that go? No, go ahead.
It's been rough, Judge. At this time, there are no offers on this file.
Here's a simpler version. This is the moment when the reality of the case really starts to hit the defendant. The prosecutor confirms that there are currently no plea deals available, and that immediately changes the situation. When there is no plea offer, it usually means negotiations have not progressed, are still incomplete, or the prosecution is not ready to reduce its position. As soon as she hears that, Miss Mason shifts away from discussing legal procedures and starts talking about her personal struggles. She explains that she is disabled, has no income, is trying to set up payment plans, and is dealing with issues in multiple courts. She sounds overwhelmed by everything happening around her. The problem is that she begins mixing different cases together, which quickly creates confusion. Her attorney keeps trying to separate the issues because Judge Simpson can only make decisions about the case currently before him. Many people watching court proceedings do not realize this. Judges must follow strict legal procedures. Even when someone is facing real financial difficulties or has problems with other warrants, fines, or cases, a judge usually cannot resolve those unrelated matters during a different hearing. You can also see another concern developing. The more Mason speaks freely, the greater the chance that she might accidentally say something that could hurt her case. Her attorney understands this. The judge understands it. Most people in the courtroom understand it as well. That is why they keep interrupting her. They are not trying to stop her from expressing her feelings. They are trying to prevent her from making statements that could create legal problems for her later.
If we could adjourn this matter, Your Honor, so we can hopefully get an offer, and if not, move it forward in another way to resolve it, Judge.
But could I talk to Judge? May I say something?
No. What do you not?
I'm ordered to pay $180, but I don't have an income because I'm disabled now. So I was trying to explain to him that I talked to a court clerk at 14A District Court. I called the bus back up there and talked to her and told her my situation. She said I could make a payment plan, but they never sent me through the mail.
Miss Mason, is that this?
Yes.
Because if that's not this case,
excuse me,
is that on this file? Because if it's not on this case, Judge Simpson cannot do anything about that today.
Well, which case is this? It got to be the one I went to. It got to be the one that I already got ruled on because is it a case from that I had a bench warrant on? It was a warrant out for me on this case because I didn't pay the $180.
Okay, you never had a bench warrant on this one.
Me?
You never had a bench warrant on this one.
Is this the one where I had the crack pipe, the paraphernalia, and I got caught stealing from Myers?
No, this is the one where you were stealing from the store, allegedly.
Right, from Myers, right?
Yep.
From Myers or Home Depot. Okay, that's what I thought.
Yeah.
And that's the one that you ruled on for.
No, this is Myers. This is Meyer.
That's what I know.
You were stealing stuff.
That's the one that
allegedly. This has nothing to do with the crack pipe. That might have happened before or after. It has nothing to do with that.
It happened at the same time, Judge Simpson.
Well, I don't know that.
You gave me 180-day rule, and you gave me
Miss Mason?
$80.
Miss Mason, anything you say can be against you.
This is the moment when the hearing goes from being messy to potentially risky for the defense. Judge Simpson is clearly warning Miss Mason that she is sharing too much information, and some of what she says could be used against her later in the case. Notice how direct the judge becomes. He stops using gentle language and gives a clear warning. Stop talking before you accidentally damage your own defense. What makes this situation unusual is that Mason keeps trying to explain her side of the story by bringing up other incidents, including a paraphernalia case and previous court decisions. At the same time, her attorney is likely concerned because every additional statement creates the possibility of new legal complications. Many defendants believe that explaining everything will help clear up misunderstandings, but court proceedings do not always work that way. Legal communication must be careful and precise. Knowing when to speak is important, but knowing when to remain silent can be just as important. Judge Simpson is actually showing patience throughout this exchange. Some judges might have stopped the discussion much sooner. Instead, he repeatedly tries to guide the conversation back to the issues relevant to the hearing while warning Mason that she is getting close to saying things that could harm her own case.
So would you please stop until we can try to get this matter resolved and we can deal with all that stuff at a different time?
Okay. So I don't want to go to no trial. What's going to take place now?
Okay. I was just going to adjourn it out so that everybody could talk to each other about it and get it. So I'm adjourning it to July 6th.
Thank you, Judge Simpson. Thank you, sir.
Thank you, Defendant Mason. All right, you have a great day.
Thank you, Judge.
Thank you, Your Honor.
There it was. Whole day just flying right along. And it happened. Okay. I'm afraid to call anymore. I just this is all Feaster.
So what happened, Judge?
Miss Kleeman, are you there?
I am.
Miss Kleeman, we don't have days like this.
I know.
I don't know what happened.
I don't know what's going on today.
Feaster,
Sorry.
no, it had to be you. This doesn't happen to Kleeman. All of what happened in the last 20 minutes would not have occurred.
Are you sure you want me to come back on July 13th?
You can almost hear the courtroom trying to recover after the Mason hearing. Judge Simpson sounds both amused and exhausted by everything that just happened. The brief conversation with the attorneys afterward is especially interesting because it gives viewers a rare look at how judges and lawyers react when a hearing goes completely off track. When Judge Simpson jokes, "I'm afraid to call anymore," he's not just being funny. He's acknowledging how unusual and unpredictable the hearing became. The attorneys laugh because, sometimes, humor is the easiest way to release tension after a stressful and chaotic court proceeding. Then comes the final joke. "Are you sure you want me to come back on July 13th? It feels like one last humorous moment before the court moves on to the next case. Judge Simpson even jokes that he needs time to think about it before giving an answer. Moments like this remind people that courtrooms are filled with real human beings. Judges and attorneys deal with unexpected situations every day, and some hearings can leave everyone mentally drained. This is also why courtroom videos often become so popular online. Viewers are not just watching legal procedures. They are watching real people react to unpredictable situations in real time. The combination of formal courtroom rules and unexpected human behavior can create moments that feel almost impossible to script.
I'll have to make a decision after some deliberation later because I don't know.
I don't know.
All right, let's try this one.
Jessica Blanche, appearing on behalf of people.
And good morning, Your Honor. Christina Costantino, appearing with and on behalf of Ms. Sierra Robinson. Ms. Robinson, can you unmute and state your name for the record?
Sierra Robinson.
All right, what are we doing?
Your Honor, this is a date and time set for probable cause conference. At this time, we are requesting that this matter be scheduled for an in-person preliminary exam at the soonest available date, and I would like to address my client's bond.
Preliminary examination in this matter will be set for May 2nd, 2023, 9 a.m., and that is before Judge Perry.
Thank you, Judge. Might I address my client's bond?
You may.
Your Honor, my client's bond is currently set at $2 million with no 10% provision. We are asking for a reduction of that bond. My client's 25 years old. It's my understanding she does not have any criminal history of any kind. She's not presently on probation or parole or anything of that sort. She is pregnant currently. And it's my understanding that she's been having some health issues while in the Washtenaw County Jail related to her pregnancy. We have some concerns that she may not be able to get the appropriate treatment for both her health and her unborn child's health. She does have employment lined up. Should she be released, she would have employment lined up at Kroger.
The mood in the courtroom changes completely at this point. The jokes and light-hearted moments are gone, and the focus shifts to a serious bond hearing involving violent allegations, pregnancy, family responsibilities, and concerns about public safety. Pay attention to the defense attorney's approach because it follows a common bond reduction strategy. She carefully builds a picture of stability for the defendant. She points out that the defendant has no criminal history, is pregnant, has health concerns, receives support from family members, has a potential job opportunity, helps care for her mother, and plans to attend college. Each of these details is presented to show that the defendant has strong ties to the community and reasons to follow court orders if released before trial. The attorney presents these facts in a calm and organized way because bond hearings are often focused on risk rather than determining guilt or innocence. The defense's argument is simple. The defendant can safely remain out of jail while the case moves through the court system. However, the challenge for the defense is that the allegations in the case are very serious. Everyone in the courtroom knows the prosecution is likely preparing a strong response. As the defense continues presenting factors in the defendant's favor, the tension in the room continues to build. This situation also highlights an important legal principle. Bond is generally not meant to punish someone before they have been convicted. Instead, judges must balance the defendant's rights with concerns about public safety and the likelihood that the defendant will appear in court. That balance can become especially difficult in cases involving serious or violent allegations.
She would be residing in Ypsilanti with her mother. I personally spoken with her mother and confirmed that. Her mother is on dialysis, and Miss Robinson typically helps take care of her mother tremendously. So she has some family obligations that a lower bond could help her to accommodate as well. She does have a high school diploma, and she does intend to enroll in college sometime in the near future should she be released. It's my understanding, Your Honor, that this warrant was authorized sometime in February. At the time, my client's address was not the same address that was on file with the felony complaint. My clients indicated she never received notice that there was any sort of warrant. And she did come in custody. That was the first time that she learned about the warrant. It's also my understanding there'd be no issue with any sort of no contact order. My client does not have any need to see the complainant in this case. So we would ask the court to consider a bond reduction from the $2 million bond. My client doesn't have any financial means to post even close to a $2 million bond. But we would ask the court to consider a $10,000 bond. And I know that's a significant reduction.
All right, I'll hear from the people, but my understanding is factually, Ms. Robinson's accused of stabbing an individual who was pregnant, and then that individual had to be induced into labor. That's go ahead.
Those are the allegations, Judge. This was a random stabbing at a bus stop. So I have huge concerns for the community. While I sympathize with the fact that the defendant is pregnant herself, she did stab the victim multiple times, and in fact said that when the victim said, "I'm pregnant," she said, "I don't give a fuck. That's why I stabbed your bitch ass." And she was induced and almost bled out on the street. So I would not be okay with any reduction in bond in this case, Your Honor. I believe she's a threat to the community.
And Judge, if I might respond.
Yes.
Your Honor, first and foremost, we dispute those allegations, of course. I'd also indicate the discovery reveals that the complainant did not ever see a knife or any other device which was used to allegedly stab her. And for what it's worth, my client was also injured as the result of this and suffered a miscarriage shortly after the encounter with the complainant. But we dispute that there was ever any sort of stabbing, which is supported by the complainant's own statements to police that she did not ever see any sort of weapon that my client allegedly had.
She didn't see it, or the person that stabbed her didn't have it? I mean, there are differences.
It's my understanding from the discovery that the complainant said she believed she was stabbed, but never saw any weapon, could not describe the mechanism by which she was stabbed.
Okay, that's what I thought. Okay. Motion for bond reduction denied. Bond will continue as set.
This is the moment when the hearing becomes a direct debate about public safety, credibility, and the level of danger the defendant may pose if released. The prosecutor strongly opposes reducing the bond and describes the allegations in the most serious terms possible. She highlights claims of a random stabbing, a pregnant victim, multiple stab wounds, and alleged statements suggesting a lack of remorse. These are the types of arguments prosecutors use when they want a judge to focus primarily on community safety rather than personal circumstances that might favor release. The defense responds by challenging the prosecution's version of events. The attorney argues that important facts are disputed and points out that the complainant allegedly never saw a weapon. From a legal standpoint, That argument is aimed at questioning the strength and reliability of the evidence before the case ever reaches trial. The defense is trying to weaken the claim that the defendant presents an immediate danger to the community. In the end, however, Judge Simpson was not convinced by the defense's arguments. His decision was straightforward. The request for a bond reduction was denied, and the current bond amount would remain unchanged. Looking back, this courtroom session felt like two completely different hearings. The first involved confusion, interruptions, and procedural chaos. The second focused on serious violent felony allegations with significant consequences for everyone involved. It serves as a reminder that court proceedings are rarely driven by emotion alone. Judges must weigh legal procedures, available evidence, public safety concerns, credibility, and the rights of the accused at the same time. Sometimes they are required to make those decisions in the middle of a courtroom that has shifted from disorder to high-stakes legal arguments within a matter of minutes. If you found this case surprising or insightful, be sure to like the video, share your thoughts in the comments, and subscribe for more courtroom breakdowns and legal analysis.